Well, hello. Welcome to Floyd Zadkovich's video series. My name is Luke Zadkovich. I'm one of the partners at the firm, and I'm delighted today to have with us Ashwin Shanker at George Rebello Law Firm, a law firm of a very rich history, and I've known Ashwin for many years now from the industry. So welcome, Ashwin.
Thank you very much for having me over, Luke.
Floyd Zadkovich, International Commercial Lawyers.
It's an absolute pleasure to have you on the show, and I'm very interested for our discussion today and to talk about some of the issues that you are facing in this very difficult time with COVID-19, and to get into how this issue is affecting things in India, as well as some of the legal issues related to it. So thanks again for your time. And just to open up, if you could give a little explanation about your firm and yourself, I think that would be quite useful.
Yeah, so we're a small boutique shipping firm. We've been around for about 30 years now. We have about 4 partners and about 6 associate lawyers, plus support and admin staff, so about 15 people all put together. Usual shipping, joy, security, ship arrests across India, enforcement of foreign awards, injunctions of bank guarantees. That's our shipping vertical. Also, there's a bit of offshore work and a bit of general commercial work as well. So it's a fairly fast-growing, youngish law firm, a bit like yours as well. And we hope to remain this size and continue to be profitable.
And how are you finding operationally dealing with this issue? I take it you're all working from home and all of that.
It's actually impacted us less than we were expecting. A lot of what we're doing, we are able to do from home. We've got a lot more problems, largely because of the demurrage-related issues that have been coming up over the past 1 month, the uncertainty in the business. So we've tackled as much as we can over the phone and email, but we have also had to do quite a few ship arrests, ongoing cargo attachment, cargo arrests. So that's been keeping us busy, yes, all of us. We've also had a few international arbitrations, which we've been working with. We've done submissions online, video. It's worked fine and profitably.
And how are you getting the arrests and the attachments? Is that all through virtual applications or?
Absolutely. So we did have initially some teething problems because courts were working only once in every 3-4 days. That's a bare minimum, maybe only 2 judges sitting out of about 30-40. It's still going on at that reduced strength, only for extremely urgent matters. Apart from just getting a hearing, we otherwise had also procedural difficulties to get over. Like, for example, documents need to be notarized, but we weren't able to get notaries around to get them signed. So some courts have been lenient and said you don't need to notarize it. It's sufficient if the client to sign on those documents, PDF it and send it to us. But those are exceptions. Also, a lot of courts have just extended deadlines on things to be done. Like, for example, a limitation time bar has been pushed ahead. All other procedural directions have been automatically default pushed ahead in a single blanket order passed by the Supreme Court. All injunction orders that were passed that were due to lapse in these months of March, April, May have also been accordingly extended. I'm sure we will face a flood of those the day the courts open and all those orders expire. There will be a lot of people then running back to court asking for a hearing or for an extension of those respective orders.
Yeah, it's really interesting to hear how different jurisdictions are dealing with those issues. In the US, for example, there was just a blanket extension of time-related procedures. All orders had an additional month added onto them or more, whereas in England, we're not seeing that on a kind of uniform blanket basis, but more on a case-by-case basis. And if you need more time, then the courts are very lenient in granting that. I've not seen a moratorium on the time bars. They are being freely, consensually extended, but there's not just an automatic extension. And so far as the courts in both the US and England, which is the jurisdictions where our firm practices, it's all continuing, but on a virtual basis in much way. And indeed, filing now, I'm not sure about in India, I'd be interested in what happens there, but filing these days in both the US and England is all online. So we can run a lot of the litigation completely virtually and from afar, so to speak. The only touch point has been for hearings, when you actually need to appear in court and argue.
And what level of hearings are you seeing happening in the English High Courts or in the United States Supreme Courts?
Yeah, in England, hearings have been continuing, perhaps not at the same frequency. And that's largely because a lot of adjournments have been sought for various reasons, and those hearings have been pushed off. But for those cases where the parties are ready to go and there's no COVID-19 related reason for extending time, then those are proceeding. I've got a trial starting on Monday, for example, for a fraud-related claim. And 2 weeks later, I've got another trial. So those are happening virtually. I haven't yet had a full hearing. I've had interlocutory hearings virtually. So it's going to be, it's going to be an experience to have a full trial from the Home Office.
And are the courts taking up only high priority matters, or are they also doing routine matters?
No, they're also doing routine matters. I'm speculating somewhat, but I suspect part of that is if the technology works, if the parties can deal with the issues in play, there are no actual practical reasons why it can't proceed, then it's better to continue to move the court docket along. Otherwise, as you say, you're going to end up with a backlog when things start opening up again. And stepping back for a moment, looking at not just our industry, but industries more generally, this is, without doubt, this pandemic is, in my lifetime, one of the worst things that, as a global society, we've had to deal with. And the devastating human and health effects are just mind-boggling, frankly, and devastating. But in amongst all of that, this has led to quite an increased uptake in using virtual means for business where we can. And I do wonder whether this period, in a way, has been an opportunity for the courts to use some of the virtual software and see how it goes. And I would not be surprised at all if some of the methods that are being used now remain in place. Not everything. We're not going to always have trials over Zoom or Skype, but more interlocutory hearings, I can see a tendency towards those perhaps being undertaken virtually, particularly in the international setting, Ashwin, where you have international clients who might want to attend, but there's a high cost in having them come from abroad. Well, what about in India? Was there much use of telephonic conferences or virtual conferences before?
We had zero, excepting in the case of evidence which was being recorded sometimes for a witness which was overseas, but otherwise it was almost never being used. There was certainly no hearings ever happening. There has been talk as well as a judgment about the need to live stream the hearings. So the hearings would happen in the courtroom, but they would be broadcast on a live stream. I don't think that was ever actually, it was recently done, so I don't think the technology has been yet up and running to implement that. It was towards the interest more of transparency of court rather than continuity, which that time was not a problem. Now they're doing it on either Zoom or on WebEx, or there's Blue Jeans. Different courts are using different softwares for this, but only bare essential urgent matters are happening. has the United States or the English bar or amongst users, has there been any arguments against the adaptation of this on a more long-term permanent basis?
I think it's too early to say on that. There has certainly not been any pushback that I've seen in using virtual means during this period. I think actually the parties, generally speaking, have embraced the technology. And it will be interesting to see after the shutdown, the lockdown ends, hopefully when that ends, whether some of this way of doing the court's business continues or not. I suspect that the bars will be interested in keeping some of it, but not too much. Yeah, so that's how I see things. In India, how are you seeing this pandemic affect trade and shipping and the industry?
So there is a genuine interruption because truck transport carrying raw materials is being affected. I'll focus more on the shipping and on the commodities side rather than general life. Some people, so cargo discharge and loading rates have dropped a lot because the clearance out of ports has been affected, resulting in ships having to wait. Also, the number of gangs for stevedores, number of barges that are available have also dropped, resulting in a slowdown in discharge rate, but not a complete shutdown, which is adding to the ambiguity of whether or not it amounts to a force majeure.
Yeah.
A lot of people are using this as an excuse not to pay, but what for payments that normally would fall due, like either charter hire or freight or demurrage. Saying some, and we don't know whether it's genuine or not, but they all claim financial difficulty, which is all a onward result of this. So payment defaults, claims arising out of payment defaults, not just interest, but people may, let's say, stop performing, stop discharging, withholdings, exercise of liens. So those are one of the triggers of legal issues. And of course, slow discharge due to non-availability of full facilities, again, resulting in whether or not it's a force majeure interruption to a late time.
Yeah. And is there a standalone concept of force majeure under Indian law as there is in civil countries, or presumably it follows the common law approach of England, where it requires contractual language setting out the force majeure?
You're right. It is similar to England. We follow the force majeure clause, and it must be clearly and specifically worded. And a lot of that has been subject matter of debate here.
Yeah, because look, we've been, I'm sure, as you and most maritime lawyers out there have been dealing with force majeure since this started, and there are a lot of misconceptions around what a force majeure clause does, and some of that is to do with the origin of the concept, and that it's interpreted differently in different parts of the world. Some countries actually have it as a principle of law, like like the frustration in English law, which is a common law principle and is not needed to be stated in the contract. Whereas if you're dealing with a common law contract like English and, as I understand, Indian, then you need the contractual language in it to be able to rely on force majeure. And the starting point in those cases is always the actual clause. What does the clause say? What events are covered by the clause? And importantly, what is the effect of that? Is it a suspension of specific obligations? Does it give you termination rights after a period of time? And one element which is very common in force majeure clauses is this concept of foreseeability and whether the circumstance is unforeseen. So if you have contracts that are being entered into after COVID-19 had spread around the world, then if it's still got that old language that we see in many clauses that says an unforeseeable event, etc., and then defines the event, you might not be able to fall within the force majeure clause because the parties could have foreseen it at the time of contracting. And that's just one issue. There's an array of arguments there. What are some of the arguments you've been seeing around?
No, so precisely exactly as you correctly list out. But some we've seen also where, let's say, COVID has happened, but one would not know whether there was going to be one would not know whether there would be a steward or slowdown, for example.
Mm-hmm.
So the contract may have been entered into, let's say, post, for example, March. The ports were still working fine, but by the time the vessel comes down, there are other slowdowns which one may not have envisaged, though the contracts were entered into after COVID. So you think that there'll be a lockdown, but you don't think that, for example, stevedores would not be available, or charter hire payments would not come on time. So it's the same point, but it gets more complicated when you run individual examples. We've got actually a lot of problems. Another issue which we face fairly often is, I appear most for bulk cargo operators, so I use that as the example for most of what we do. So let's say most commonly demurrage is payable X number of days after completion of discharge of the cargo. And this is cargo coming into India, for example.
Yes.
At every point of time, say demurrage is payable 7 days after completion of discharge. During the discharge, the operator doesn't know whether or not he will get his demurrage. The receiver/charterer does not raise force majeure at that time because he's not obliged to, under the contract, mention that he's going to be using a defense of force majeure. Or maybe he does as well. But there's also whether the lien can or cannot be enforced because of this ambiguity. So one way we often have recommended to our operator clients is when you can't exercise the lien because the demurrage, either because the demurrage has not yet fallen due, or because the owner of the cargo is somebody who's different from your debtor charterer, do not issue delivery orders against an LOI. Insist on production of the original bill of lading.
Yeah.
What that does is, because original bills of lading are not reaching discharge ports due to courier shutdowns, it effectively, you know that you will not get the OBL, and you can indirectly exercise a lien which you would not have otherwise been entitled to exercise under the contract. And that gets you the upper hand bargaining position to be able to recover the demurrage which is in dispute.
Yeah, I think that's a great idea. I like your thinking there. One point of caution on that is, of course, if the charter party itself already has the indemnity language in it, and we've seen that. If I think back over the last 10 years, it was rare to see the LOI indemnity language actually sitting in the charter party itself. But as the years have gone on, there's the language saying that will deliver without presentation of bills against the club wording. But now we're seeing more and more some of the actual language, the operative language that you would see in the LOI itself, sit within the charter party, and it's almost like agreeing to the LOI up front. So assuming that that is not in the charter party, then I think that's a great idea.
So we had this in 2 of our cases, and one of them, we got the LOI from the charterer, but the charterer then, in the week when he issued the LOI, went into financial distress. There were insolvency proceedings filed against them. And on that basis, we've recommended to clients that you attempt to not act on the basis of this LOI, because it looks highly unlikely that you will ever be able to collect under the indemnity for the value of the cargo should there be a misdelivery. And we try to use that as a justification to bypass this clause. Another one which we did is we asked ourselves as to what would be the damages payable if we were in breach of this obligation to discharge against an LOI. And we weren't able to put a number to it. And therefore, we weighed the risks, and we thought it more practical to put pressure on this way to collect our demurrage, because there was highly unlikely that that the charterer would be able to quantify what his losses are as opposed to the receiver's losses are, as a result of our insisting on a bill of lading and not a letter of indemnity.
Yeah, that's interesting, because I see the issue as against the charterer, but when it's the receiver who's seeking to leverage under the bill, that's its contract, against the operator owner, the obligation to discharge. I see your point that it may not necessarily follow that the receiver can rely upon the indemnity provision as between charter and owner to insist upon delivery without bills of lading. Yeah, I see that argument.
And the quantification of the claim is difficult for them to put a number to it. So
there's also, it strikes me with that type of clause that depending on how the indemnity provision I'm talking about in a charter party, depending on how it's worded, I've wondered previously, not in this context, whether some of them are actually worded as an agreement to agree, and that some are definitely agreed as an indemnity at that point in time. But some of them talk about, owners will do this if a club LOU is issued, and there's often a debate about exactly what goes in the final LOU and what's accepted. Is that a bank countersigned LOU, which is club recommended, or is it not, which is usually the case? So if the language is saying, we will deliver against a club LOU, owners arguably could say, well, fine, but it has to be a club countersigned by a bank LOI, sorry, not LOI. And I think there's an argument in there. I do. Fascinating, yeah.
These ways are essentially to force to get a lien, and then to extract demurrage, where you later on think that you've given up the cargo and you'll be faced with the defense of a force majeure struggling, putting you in a difficulty to then collect in a whole long drawn arbitration and then an execution. So it's a shortcut pressure tactic.
Yeah, exactly. And that's really that's the objective at the moment, is to maintain some form of pressure, some form of leverage, so as to protect your position, particularly if you sense that your charterers are not going to be for an operator anyway, are not going to be in a position to pay on time. There are often levers that you can pull to strengthen your hand. And so, are you seeing an uptick in attachments or other type of asset seizures?
We're doing a lot of ship arrest work now. Routine bunker supply most commonly, but also a lot of attachment seizures for this unpaid demurrage for exactly the same issue. So where in fact I was on a call just now on this as well as yesterday, and all of these are fairly complicated because you have multiple parties and they have different stages of delivery. Sometimes they want to attach the cargo after having issued delivery orders, which means that they've already parted with possession notionally. So it gets more complicated with that. Sometimes the receiver is different from the charterer, so you have an innocent bill of lading holder claiming entitlement to delivery of the cargo.
Right.
I'm sure you're facing a lot of this kind of inquiries as well.
Yeah, we've definitely seen an uptick in that, particularly on the US side. So as you know, we advise on both US and English law when it comes to asset attachments and vessel arrests. We tend to see more on the US side of things because that's where a lot of companies have assets, whether they're passing through or they have it located in the US. So we are seeing an increase in inquiries about attachments, Rule B and Rule C. So Rule B being both maritime type attachments, but Rule B being for going after the property of a defendant that's not found within that state, within the jurisdiction, in support of a maritime claim, and Rule C being the vessel arrests.
And between the United States and UK, are there any striking differences between how force majeure are treated?
Not really. There are differences on what elements of a force majeure may mean. So, the definition of a labour strike may be slightly different in the US or in England, which is a product, as you know, of the common law looking at certain elements slightly differently. But going back to first principles, they both rest on the premise that for there to be a force majeure, the parties need to agree upon it. So you are looking at the contract, you're looking at construction interpretation principles when you're looking at the clause. A lot of those construction approaches are similar between the two jurisdictions. But then when you start to drill into specific words and what they can mean, there are slight differences there. But for, you know, at a high level, I think generally speaking, they have the same type of effect. So we're seeing, and as I said before, the various arguments around force majeure. We're also been looking at safe port type arguments. We've had some arguments around frustration. If the force majeure clause doesn't bite, is there frustration? That's very unlikely, I think, in our view. But we're seeing those types of arguments at least being asked by clients. So yeah, but coming back to attachments and arrests, the US, well, going back a step, once upon a time, Rule B was very prevalent, obviously, in its usage in the US. Rule B, which is a procedural rule within the federal civil procedure rules, has not changed. The actual rule itself exists, and there's been no change to the rule. What has changed is the court's interpretation of whether an electronic funds transfer, an EFT, is to be considered as property at the moment it's passing through and clearing through a New York clearing bank. And for a number of years, it was held that when it passes through New York, that EFT was property, and so therefore could be attached by parties. And the Jali decision, which is probably over 10 years ago now, it overturned that that finding, and pretty much led by the amicus curiae brief of all the banks of New York, decided that an EFT is no longer property. But that doesn't change the fact that, just excuse me for a second. So other property is still very much attachable. So whilst an EFT itself is no longer considered property within New York as it passes through the clearing bank, other property that you can find is. And other property can extend to anything really. So it could be cash. If you know that a counterparty has a bank account in the US and there's actually money sitting in a bank account, you can attach that. If you have cargo, bunkers, a vessel, anything that is owned by your counterparty, assuming that the counterparty cannot also be found in that jurisdiction, that's attachable. Trade receivables, if there's an open account between trading partners, and we've used this to good effect, if your counterparty has business with other companies in the US, depending on the flow of that trade in which direction and who owes who, sometimes you can go after the trade receivable account. And in these times when people are seeking to extend credit and there's longer payment terms, often there's an open account there and there's a receivable to attach. Claims, judgments. So we've had cases where, actually one of the very large cases that I've had with Ed that we worked on prior to actually setting up the firm when I was in England and he was in New York, was a misdelivery claim, and the charterers, Swiss traders, didn't honour an LOI, and it was delivery without bills case, as we were talking about before. And we were really struggling to find any assets. We got an English freezing order, enforced that freezing order in Switzerland, and we just were not getting anywhere, honestly. And Ed managed to track down an insurance claim that the charterers were pursuing in the US against a completely unrelated insurer, and it turned out to be a good claim. So we attached it as a claim when it was being pursued in court proceedings, and attached it then. The other side, the charterers, tried to challenge whether the indemnity claim was ripe for the purposes of Rule B. That was debatable. And in the time that we were waiting for the judge to rule on the challenge to the Rule B attachment, the underlying claim the property that we had attached, the underlying claim, it turned into a judgment for like $10 million, and we'd attached the whole claim. So the charterers then turned around and said, okay, you can have your security for $5 million, and they wanted the rest in cash very urgently. So we ended up getting full security on that one. But there, as I say, Rule B is very much alive if you have some property, and we've developed a number of ways of tracking down property and thinking through where it might be. And so we're seeing a number of clients coming to us and saying, what can we do? We're owed money. It looks like they may be late. Can we use Rule B as a way of applying some pressure to get payment through?
I've always found New York lawyers very clever in finding correct but gaps to fill up the need of business, and a lot of cooperation from the United States courts as well to provide these recovery or security methods as well.
I think that's fair. If anything, we were too good at it, which is what brought on the banks. The banks were being swamped with Rule B garnishee papers, and the admin costs alone were quite high. So anyway, in hindsight,
I remember reading the order that time, the Jaldi order, and I thought it was a decision of practical convenience, but not on law.
Oh, I entirely agree. And we have thought long and hard about, whether it's worth trying to challenge that. The trick there would be you need to be ready to take it all the way through to the Supreme Court. To get any traction would be difficult at even the first level. And to get to the Supreme Court, you need a circuit split. So there's not many payments, EFTs, being cleared in other states than New York. So it's hard to envisage how you can get sufficient circuit split. There are some places where it might be possible, but it's quite remote. So we've been looking at other ideas, and under Rule C, so Rule C is a different procedural rule that's primarily dealing with vessel arrests, where the actual vessel, the rem that you've got a claim against, is in the jurisdiction, and so you're arresting that ship because it was involved. And that's like any arrest procedure, and quite straightforward, and we all know how that works. What we've been looking at, though, is the definition of a vessel, and what can be considered a vessel. And under US law, at least, and perhaps other places, the definition of the vessel itself can extend to freights payable to that vessel. And under that type of argument, we have developed an argument. We haven't yet deployed it successfully, or haven't tried to. We've been waiting for the right case. But in theory, we think that it might be possible under Rule C to attach a freight payment as it passes through New York. And there's some, I won't go into the detail of it, but there is some reason to differentiate Rule B and Rule C when looking at the question as to whether the freight is actually in New York or not. And that's, as you say, it may have been a decision of convenience in a Rule B context. When you actually look very closely at it on this issue as to is there property at any point in time in New York, it's quite a hard construction to say at no point in time is there anything in the hands of the New York bank, one way or the other. And because the Jowdy decision would not have direct applicability, it would have persuasive effect, I'm sure, but it wouldn't have direct applicability to Rule C in this question. There may be a way of levering open the debate, at least, to have that heard again. So watch this space, where if we can find the right case, it may well be worth looking at. And the right case would be one where you have a claim against a ship, you expect that ship's going to continue to be paid freight in USD, and you have some grounds to know where its bank account might be and what clearing bank it would use. The narrower you could make it, the better. And then you, like you used to do with the Rule B, you would garnish the bank in New York, it may be that the payment requires freight written on it, which a lot of them do, on the actual EFT wording, the SWIFT. That's an area for debate, but a lot of them have the word freight. And if you ran a search for freight through a bank system for a particular name, you might get some hits. So that's an idea. I don't know what you think about that one, Ashwin. But
very interested in this. As I see it, it's for the world, it's easy to recover money from ship owners. It's quite easy to recover money from the actual cargo interests, but it's the most tough to get money out of ship operators. They are asset light, often come in and out and disappear a few years later on. So collecting money from them is difficult, and this may be one of the solutions for that if it works out. I wonder, when you say freight, I assume you mean the freight beneficiary, which means the recipient of the payment is the one who's
yes,
against who you need to have a claim against, not the payer.
Exactly. Yeah.
Because it's not very difficult to tell. You can tell when somebody is loading cargo, and you can, from experience, know that freight usually gets paid about 5 banking days after the bill of lading. So you can kind of earmark the week in which you'd expect the money to flow.
Exactly.
Set up an alert. What about, let's say there was a notorious defendant who I need to collect money from, and he's got an account with a bank in an inconvenient jurisdiction, but that bank also has a branch in, say, the Southern District of New York. Would we be able to use that to attach his money lying in an account in the other inconvenient jurisdiction?
It's a very good question. Typical lawyer's answer, it depends. But there's this argument around different banks in the US being separate entities for the purposes of attachment. And a lot of banks are structured that way. However, and also internationally. So the entity that's in the US for a bank and its counterpart overseas, from a corporate sense, they're actually different businesses operating under the same brand name, same banner. But not all banks are equal in this respect. And some banks, particularly those in, as you say, quite inconvenient jurisdictions, they have more like passporting rights or correspondent banks, but they're not they're not fully distinct from the other bank. It's almost like they're holding an account themselves over in the US, and they don't have the full setup that creates the distinction in a corporate sense. And we have actually looked at this before, where, and I'd have to chat with Ed about it, whether he's actually pulled the trigger on it, but I know we've actively talked about it, is that there are some banks out there where we think they are exposed in the US to a Rule B attachment because they haven't got that corporate distinction between the money that's being held in US and the banking operations outside of the US. So if it's a mainstream bank like a Citi or a HSBC, perhaps not. But some of the other, the lower tier banks, depending on how it's structured with the US, there can be options there. There can be opportunities.
We've got some interesting inquiries on a different context where certain countries have not announced a lockdown, it's on the force majeure point, but have declared what they call a holiday for that week or for that month, intending to be this. And the lockdown, it's called a holiday, but it's a holiday with restrictions, so you can't travel and you can't do this. Why it becomes relevant is in charter parties, you have a force majeure clause, but you also have a holiday interruption to the running of late time. So you have a clause which typically says, say, checks EIU. That's Sundays and holidays excluded even if used. So during the entire running of what cargo discharge should have, for example, taken 3 days, ends up, for example, taking 30 days. The entire 30 days gets naturally excluded because it's been declared by that state as a holiday, even if used. So time doesn't count. So then, again, the whole issue arises as to how do you treat that period? Is it actually a holiday as the charter party would consider it, or should it be looked at from a force majeure perspective, or is time still supposed to run?
Yeah, that's fascinating. I've not seen that one myself yet. Well, it depends on which side of the argument I'm on. Yeah, there must be something around, and I'd expect there's parallels out there as to the reality of the order. Just because it might have the label holiday, is that in reality what this is, or is it a government intervention and more of some type of stay, effectively, of operations? I think I'd probably like to be on that side of the argument, that the nature of this, whilst called a holiday, is actually government action to shut down businesses. It was quite interesting at the outset of this issue in the UK. The government, you could tell, was very careful in the UK government in whether it was saying that the government was ordering a shutdown or not. This is when it was first happening, first playing out. And I couldn't help but wonder whether that was in part driven by an analysis of what is the legal effect of a government making that type of decree. Because it impacts on all sorts of business interruption policies from an insurance perspective. It also may impact on businesses' ability to claim certain benefits from the government itself, depending on what's set out. This is personal speculation in this respect, but what a government says and the nature of the action it's taken can be looked at differently depending on the context in which it's impacting. And I wonder whether there may be some analogies to draw in that case, with other business contexts, like a business interruption policy or an insurance policy that deals with that, where courts have looked very closely at what is the actual government decision here? And a government could come out and say, we recommend this or we recommend that, and not put forward an actual enactment or statute, and still it has the effect of shutting down business. Is that sufficient? You know,
We've got exactly this issue running in India. The Director General of Shipping has issued ambiguous notifications where he has recommended ship owners not to charge ground rent or demurrage. He says, we advise you. And of course, both sides of the trade are interpreting it differently.
Yes.
Another problem we've been seeing of late is with the drop in bunker price as well as the drop in commodity price, voyages from, say, Asia to the United States or vice versa, which used to traditionally use the Suez Canal route, are now taking the longer route because it's become cheaper. Charter rates are also low and bunkers are also low. So they're doing that through the Cape, and voyage durations are therefore getting much longer. As a result of this, we find two kinds of problems: either cargo deterioration claims or claims for drop in value of the cargo. Because it's just the market for everything is now dropped. So we're seeing a lot of inquiries from claims from receivers against the carriers under bills of lading, pointing out that the voyage was not carried out with a reasonable or quick dispatch because it chose a longer route. But some would argue that going round the Cape has now become the norm to prevent the Suez Canal charges. So, and therefore it still fits in within the definition of route.
Yeah, and prosecuting the voyage with due dispatch. Interesting. Yeah. Okay. Did you have any other topics that you wanted to touch on today, Ashwin? I found it fascinating to hear what you've been up to.
I'm sure, and I hope the English arbitration has a clear answer to most of these, and it gets flooded and quickly tackles all these questions between the entire trade around the world.
Yes, me too, very much so. I'm sure we'll get some answers to these questions soon. And in the meantime, it's a question of, as we said before, leverage and pressure, and trying to help our clients through a very difficult situation. Look, most importantly, it's good to see you. I'm glad you're in good health and with your family and your colleagues and all of that. My best regards. Let's hope that things start to turn around in the world's response to the pandemic, and that these lockdown periods will be effective, and that the economy can start to build up again. But for today, Ashwin, thank you very much for your time. It's been an absolute pleasure to catch up with you, and I wish you well through this very difficult period.
I wish all the families and colleagues at Floyd Zadkovich a quick recovery back to business, and hope things are back to business as usual.
Thank you very much.
Thank you for having me over.